Hi friends, so basically today I will be doing Constitutional Law of India, second. So what do you mean by ordinance making power of the President, and under what circumstances President can use his ordinance making power? Can the President misuse his ordinance making power? If yes, give suitable examples. So friends, this is about ordinance, and it is to be noted that it is the most important legislative power, and according to Article 123, if the parliaments are not in session and President is satisfied that the circumstances exist where he can render immediate action and issue ordinance, it can be done. So ordinance is issued by him, and it has the same effect as an act of parliament, and this can be laid before the both house of parliament and can cease to operate if there is within 6 months or from the date, if there is a reassembly of the parliament and both houses disapproves it, and it is at the expiration of 6 weeks. So 6 weeks means around more than 1.5 months, more than 1.5 months. So basically, so President, if he likes, he can withdraw such an ordinance, and it is under Article 123. It has the same effect as that of Parliament, which I have already told, and it is vested in the hands of President to deal with unforeseen and urgent matters. It is to be noted further that ordinance making power is exercised by the President on his own satisfaction. The court cannot inquire into the reasons for the subjective satisfaction of the President or into the sufficiency of those reasons. Okay, then the question is as to whether a statute is a constitution or not is always a question of power of the legislature, concerned depending upon the subject matter of the statute. The motive of a legislature in passing a statute is beyond the scrutiny of the courts. Ordinance passed under section 123 and 213 stands on the same footing. So it says that thus the validity of ordinance cannot be challenged on the grounds of non-application of mind. So more so when it has been promulgated on the basis of policy decision taken by the government. Okay. Under what circumstances President can issue ordinance? So an ordinance can be issued only when both the houses of the Parliament are not in session. Okay. It follows from this that an ordinance can be issued when only one house is in session, because a law cannot be passed by one house alone. One house is in session. It cannot be passed alone. So law अगर बना रहे हैं तो दो houses मिलके बनाएंगे, अगर वो नहीं हो रहा तो president बनाएंगे, और ऐसे करके, और दोनों हाउस अकेले अकेले नहीं बना सकते लॉ बनता है तो, ठीक है. So it is to be noted that satisfaction is not the personal satisfaction of president. In reality, it is the satisfaction of cabinet on those advices. The president exercises his ordinance making power. Ordinance making power of president is co-extensive with the legislative power of the parliament. That is to say that it may be related to any subject in respect of which Parliament has power to legislate. Hence, an ordinance will be void insofar it makes any provisions which under the Constitution the Parliament is not competent to make. Right? Clause 3. So, this is about ordinance. So, you understand about it, right? Now we'll understand clause 3. An ordinance cannot violate fundamental rights. The validity of ordinance making power of the president can be challenged in a number of cases, and the court can uphold its constitutionality in all of these decisions. So what are these cases? This is R.K. Garg versus Union of India in 1981. 5-judge bench of Supreme Court by 4:1 majority held that the Special Bearer Bond Immunities and Exemption Ordinance 1981, it was decided in this case. So this is there. This is about ordinance. So friends, I hope all of you are happy, and I will be giving you notes like this. It is important to understand why we are doing all this, because we will be learning about AIB in detail and all those exams, and we should know about these terminologies of ordinance and law, and re-revise it for our legal uh, legal knowledge and legal upliftment. So friends, now what do you understand by colorable legislation? I'll explain. So KCG Narayan Dev versus State of Orissa, 1953. It says that the Supreme Court explained the meaning and scope of doctrine of colorable legislation. Literal meaning of colorable legislation is that under the color of or under the guise of power conferred for one particular purpose, the legislature cannot seek to achieve some other purpose which is otherwise not competent to legislate. KCG Narayan Dev versus State of Orissa. What do you understand by this? So basically, I will explain the case in here, and will understand what do you mean by this. So let me tell you the facts. Okay, so Supreme Court has explained the meaning and scope of doctrine of colorable legislation. If Constitution distributes the legislative power amongst different legislative bodies which have to act within their respective spheres marked out by specific legislation entries. अगर कॉन्स्टिट्यूशन लेजिस्लेटिव पावर को डिस्ट्रीब्यूट करते हैं डिफरेंट लेजिस्लेटिव पावर बॉडीज़ के अंदर जो कि अपने रिस्पेक्टिव स्फीयर्स में ही एक्ट करते हैं एंड अदर लेजिस्लेटिव में नहीं करते, और दे आर लिमिटेड द लेजिस्लेटिव ऑन देयर अथॉरिटी इन द shape of fundamental rights as to whether the legislative in particular case has not in respect of the subject matter, statute or in methods of enacting it transgender the limitation of its constitutional powers. So this is about it. Such transgressions may be patent, manifested or direct, but if it may also be disguised, covert or indirect, or it has to do this later. Classes of case that expression colorable legislation has been. This is about it. Who has the first propounder of doctrine of separation of powers? So this is the third question. Who has the first propounders of doctrine of separation of powers? In the context of Indian Constitution, what does it mean? Doctrine of separation of powers. Doctrine of separation of powers. So on a casual glance at the provisions of the Constitution of India, one may be inclined to say that the doctrine of SOP is accepted in India, separation of powers. Under the Indian Constitution, the executive powers are with the President, the legislative powers are with the Parliament, and the judicial power is with the judiciary. Very nicely explained. The President holds his office for a fixed period. His functions and powers are enumerated in the Constitution itself. Parliament is competent to make any law subject to provisions of the Constitution, and there is no other limitations on it, legislative powers. Similarly, the judiciary is independent in its field, and there can be no interference with the judicial functions either by executive or by legislature. The Supreme Court and High Court are given the powers of judicial review, and they can declare any law passed by the Parliament or legislature as ultra-vires or unconstitutional. Kanaiya. So Golaknath versus State of Punjab, Subba Rao's case. Right? So this is about it. Then you have discussed briefly the financial relations between the Union and the state in India. What are the constitutional limitations upon taxing powers? According to D.D. Basu, no system of federation can be successful unless both union or state have at their disposal adequate financial resources to enable them to discharge their respective responsibilities under the Constitution. What it says, according to D.D. Basu, no system of federation can be successful unless both union and state have at their disposal adequate financial resources to enable them to discharge their respective responsibilities under the Constitution. It is a fact that if the legislative and administrative authority of the constituent units are to be maintained, they must be autonomous financially. However, this principles of federalism has not been fully implemented in any of the existing federations of the world. In Canada and Australia, the sources of revenue allotted to the units are so meager that they have to be substantially assisted by central grants. American Constitution tried its best to ensure complete financial independence for both union and states, but with the passage of time, increased obligation of the state due to the advent of the concept of positive state have made them rely on grants and aid from the central government. In India, the scheme of distribution of sources of revenue between center and the state is based on the scheme laid down in GOI Act 1935. The farmer of Indian Constitution desires that the scheme of financial relations to be flexible and adaptable to varying needs and renewable sources of the states, renewable periodically in the light of experience of central resources of the state's needs and available date. So this is about it. For this, they recommended for the appointment of Financial Commission to review the whole position from time to time. Constitution under Article 280 therefore provides for the appointment of Finance Commission within 2 years of commencement and thereafter at the expiration of every 15 years or earlier if the President considers it necessary. The Finance Commission is to recommend to the President the requisite changes to be made in distribution of taxes between Union and States and define the principles on which the Union government was to make grants in aid to the states. So this is about it. I will now relate to the question and answers, and let's just go back to those things. Attorney Journal, what do you mean by Attorney Journal? What is money bill? So I will go for money bill. Okay. Article 110 subsection 1 defines that a money bill is a bill which contains only provisions with respect to all or any of the following matters: taxes, the imposition, abolition, remission, alternation or regulation of any tax, the regulation of the borrowing of money or giving of any guarantee by the Government of India, the custody of the consolidation fund or the contingency fund, the payment or withdrawal of the money from such fund, the appropriation of money out of the, so basically taxes, the imposition, abolition, remission, alteration, regulation of any tax, right? So the appropriation of money out of the consolidation fund. So this is the clearing of any expenditure to be charged on the CF of India, cash fund. So the receipt of money on account of consolidated funds of India or public account of India, or the custody or issue of such money, or the audit of the accounts of the Union or of the state, any matters incidental to any of the matters specified in clause A to F. Explain the various jurisdictions of Supreme Court. Okay, the Indian Supreme Court enjoys a number of powers evident in its jurisdiction. They are of the following kinds: original jurisdiction, writ jurisdiction, appellate jurisdiction, advisory jurisdiction, revisory jurisdiction. These are the jurisdictions, right? So these are the ones. I'll come back and take care. Bye.